If everyone has their copy and the original has been returned, we're going to go ahead and call our meeting to order today. Let me first thank our committee for the work that everyone has put in, to include Mr. Harbin and Mr. Pack, who's not with us today, but everybody has pitched in and done a great deal of work for this particular committee. I also want to thank Ms. Travis for her hard work. I know working with us is kind of like pulling teeth sometimes, but she's a pretty good sport through it all, so we want to thank her for her work. And we want to thank Tara as well for working with us. This brings us to the close of our meetings and our work on this, and this is the study committee on compensating those who have been wrongfully convicted. And our report is going to be in the form of this bill that we want to present to the members of the General Assembly, and we hope that we are able to get their support on it. But before we close out our work, we wanted to meet again and let anybody who has any concerns or questions feel free to take the mic and express those or share those with us. There were some things that we wanted to do that legislative council tells us that we cannot do. And so this is our best effort, our best first effort at what we would like to do. One of the things that the members said, we want to take the politics out of the process and make it just be an automatic once the person meets all the criteria. We're not able to do that. It has to be in the form of a resolution. So basically what we have before us is a set of guidelines that will start everybody off on a level playing field, those persons who have been wrongfully convicted. It will give us a number to start with in terms of how much we're going to allow per year of incarceration. And that number is based on the national average of the $50,000. Is what we decided to go with in this particular piece. The other thing that I would say is that you'll see in this bill that we have added some additional, well, maybe different responsibilities for the commission as they review this, and I believe it will get us started in the right direction. Of course, we had to be mindful of the fact that we cannot bind future legislators to some of the things that we may have wanted to do. But with that, I'm going to yield to Ms. Travis, and she's going to walk through this with us. And then we're going to see if anyone from the audience has any information or questions or suggestions that they want, and then we'll hear the final words from our committee. I need your number. Okay.
Thank you, Chairman. I will walk through this bill, but just a prefatory remark with respect to what my opinion is on what y'all can and cannot do. It is my opinion, and y'all are free to disregard it, but I've given you some constitutional citations to keep in mind in going through this process. But y'all are the lawmakers. I'm just here to serve. So I'm just going to walk briefly through this bill because we have spoken about this a few times before, but Section 1 of the bill is legislative findings. Section 2 of the bill and sections 2, 3, and 4 of the bill are all code sections that are in Part 2 of this particular article of the code. Just to give you a frame of reference, we're in Title 28, which is the General Assembly. We're in Chapter 5, which is Financial Affairs. We're in the article that is called the Claims Advisory Board. And then that article is divided up currently into 3 parts. 1, General Provisions. That's where the changes are made in Sections 1 through 4 of the bill. Part 2 are claims against the state departments or agencies, which is generally where a claim of this nature would have fallen. Part 3 is compensation for people who are injured while preventing a crime or aiding a law enforcement officer. And that brings us to Section 5 of the bill, which is a new part to this particular article that's going to be known as the Innocent Persons Compensation Act. So the short title is Section 28-5-110. 28-5-111, it explains what the authority is to consider the recommendation and from people submitting information, and the board's ability to appoint a special master to conduct investigations, which is similar to their authority under Part 3 of this article. In Section 28-5-112, that it is their person's specific eligibility to be able to receive compensation pursuant to this act, and it includes the criteria that would be pertinent, including the fact that if the person pled guilty pursuant to an offered plea, that would still allow them to be able to seek compensation. Subsection B of that code section explains that when a claimant's conviction is reversed or they're granted a new trial and the indictment doesn't go forward, that the court would have a responsibility to tell the individual about the availability of making a claim pursuant to this part. 28-5-113 is the statute of limitations, which is going to be 3 years in order to file a claim under this kind of under this part of the code, and that the board would come up with forms for the person to use and to submit their information to the claim. It also gives the authority to gives the authority to the board to set a hearing and call any witnesses that they think or hear any evidence that they believe is necessary for them to make a determination of the claim, and that the board would also have the authority to make rules concerning those types of hearings, and specifically does not require the claimant to be represented by an attorney. Section 28-5-114 is the specifics of what would go into a recommendation, or what can go into a recommendation by the board. That is, if the claimant had been incarcerated for 4 years or less, it would include $50,000 per year in a lump sum award. If the imprisonment was for more than 4 years, it would include a lump sum of at least $50,000, and the rest of it would be paid in an annuity. It would also allow the claimant to request tuition for up to 120 hours of schooling at either a technical school or one of the schools in the university system, and as well as payment of the student fees, and also would allow the claimant to obtain reasonable attorney's fees and other expenses if they did have counsel assisting them. That's paragraph 5 on line 129. In calculating the time of imprisonment, the person doesn't get credit for any time that they're serving another sentence, but they do get a pro rata share of whatever portion of a year that they are incarcerated. Subsection C allows the benefits to go to the claimant or to their to others in their family. The board has a requirement under subsection D to let the General Assembly know about the number of claims they're receiving, so that the General Assembly can try to appropriate the correct amount of money each year, keeping in mind what the claims are that are coming in. At line 151 in subsection E, it sets out the time frames for submitting claims. So if somebody had a claim recently, they would have had to have submitted that information before the 15th day of October. Basically, subsection E is just allowing sufficient time so that the board can act and get that information together and get it to the General Assembly so that a resolution can be introduced in the appropriate year. Section 28-5-115 reiterates that this has to be done by resolution. Again, keeping in mind the same time frames as the other resolutions that are in the same part, in the same article, that is that the resolution has to be submitted before the 10th day of the regular session, and it's acted on, it goes directly to the House Appropriations Committee and is acted on accordingly with other resolutions. 28-5-116 is preparing the, is another transmittal of information regarding these particular claims. And then 28-5-117 are the limitations on these types of claims. Lastly, Section 6 of the bill is an effort to go closer towards automatic record restriction, although I'm not 100% sure that that is, I mean, I think that would solve the problem. I don't know if the prosecutors are going to be happy with the language that's in that particular code section that we've put in there. We do have a lot of automatic record restriction that was done in the Criminal Justice Reform Act of 2012. Didn't take effect until 2013, and this would be able to be a look back. So that's the extent of the bill.
Thank you, Ms. Travis. Does any member of the committee have a question before we go to the audience? Mr. Mayo, number 25.
Thank you, Madam Chair, and thank you, Mr. Travis, for your great work on this. Question, I know we've discussed this, but would you please remind me the North Carolina versus Alford case? We talked about the Alford scenario under which we would pay a claimant even in the event they pleaded guilty. Why would we want to compensate someone who's pled guilty?
I can see Mr. Allison's ready to answer that one.
Mr. Allison?
You don't mind if I answer that?
Sure, help, please.
Having practiced law for almost 18 years and having done criminal work for 10 of those years, I can tell you that there are at times clients who will come in and they will insist on their innocence regardless of the weight of the evidence against them. And oftentimes, a district attorney would be inclined to give you a plea deal that would be something that might be acceptable rather than risking overwhelming evidence. An Alford plea was established in 1970 when a gentleman went to the Supreme Court to say that I should have a right to keep my claim of innocence while still accepting the idea that I could get a lesser sentence for pleading guilty. So what you would do is you go in front of the district attorney, you ask the judge to basically take your plea of guilty under North Carolina v. Alford, which is basically you saying, I am not proclaiming my guilt here, but I do understand that the weight of the evidence could bring a reasonable jury to convict me, so therefore I'm going to take that deal. So you may have someone that might be looking at, maybe a 30-10 sentence for a sexual assault. If he goes to trial, he might get 20 years to life. It might be worth pleading guilty under Alford in order to take a fixed deal rather than not knowing what you're going to get and risking a conviction. Okay. It's a very rare circumstance, but as I had noticed in our first meeting, the District of Columbia, that was something they inserted, and that was something that I asked Ms. Travis to insert as well.
Mm-hmm. Thank you.
Any other questions? Okay. What about the ladies in the audience? Do y'all have any comments for us this morning?
Thank you so much for your work. Thank you, Ms. Travis. It was great. Thank you. It is an exceptional bill.
Y'all are good with it? Okay, gentlemen, can we have a motion that we'll make this our official report?
I move that we adopt this bill as our official report for this study committee and present it to the Georgia House of Representatives.
I second that motion.
Thank you, gentlemen. We have a motion and a second. All in favor? We're going to say aye.
Aye.
Okay. Well, this concludes our work, and this is going to be our report. And again, I want to thank Ms. Travis and Tara for working with us, and also Ms. Williams, Stacy, for working with us. And thank you all for your interest as we move through this process. We've had an exceptional committee, and I think this is a good effort on our part, and we'll see if we're going to be able to be successful as we try and move it through our General Assembly. So unless somebody has anything else, we consider ourselves adjourned.